But so this is a disclosure class 101, so it's really for beginners, but anybody can chime in and say, Pat, I don't agree with you, or can you explain that because I don't understand it. If you could hold off until the very end of the form, that would be the best. But if you can't, like it really isn't making sense, then go ahead and interrupt me and we'll go over it more. So let me share my screen. Let me get my picture out of here. There. Okay, so I am going to be going over the newer forms first. This one is actually almost a year old by now. Anyway, it's the COVID Property Entry Advisory and Declaration Visitor. There are two of these forms. One is for seller, one is for visitor. And these are the forms today are mostly for a buyer's agent, which you will need to know. Anyway, this one is visitor. So every time you go into a property, you are going to need one of these, this form, not one of these, this form. You can put in multiple addresses here. So if you're showing 4 properties, 5 properties, 2 properties, you would put them both in here or all of them in here. And down below, and we'll go over this form in a second, you initials, signers. This is not sellers, it's signers initials. That means buyer, buyer, agent. So, or buyer and agent, but your initial has to be on there too if you're the one letting them in. And then down here is, I'll get to that one. Okay, so the risk of exposure for COVID. Everybody knows about COVID these days. And it's a highly contagious disease, or yeah, it's a disease. And there are government orders, and we have to stay in the orders that the government mandates. And the federal government mandates some. We would have the federal government, then the state government, then the counties, and then the cities. So it's the one that's closest to you that you have to abide by. So we have visitor advisory. Visitors are advised that if you engage in any activity in violation of any COVID-19 directives, you are acting against the advice of the broker. Broker and agents will comply with COVID-19 directives, notwithstanding any party's instructions, and will obey all fair housing laws while pursuing safe COVID-19 practices. Nothing contained in this form shall be construed to follow an activity that's otherwise prohibited by law. You are required to take all reasonable steps necessary to protect yourself and others. Now, the purpose of the entry, you have, when you are showing homes, you are supposed to have viewed everything online first. The buyer is supposed to have. And they like it enough to potentially want to buy it. And that is the reason you are showing this property. We don't want looky-loos looking at property. We don't particularly want the neighbors looking at property because they're not in the market to buy. Now, if they're looking for a relative of theirs, that's totally different, but try not to do let's go look at that house and see what it looks like. I mean, hopefully your buyer has the potential to purchase a property. So down here it says following all federal, state, and local laws, stay-at-home orders, even though they may be changing rapidly, exercising care to protect yourself and assessing your own risk by considering your age, underlying health conditions, recent travel, possible exposure to COVID-19, doctor's recommendation, local, state, and federal recommendations. You agree and understand that this is the responsibility to evaluate the risks and protect yourself. This is to the buyer. The buyer is the one that needs to read this form, but you have to know what's in it also. Washing your hands with soap or water. They should be doing this for 20 seconds. It doesn't say that in here. And then remember not to touch your eyes, nose, and mouth. Wearing protective face covering. What I suggest you as a buyer's agent, always have face coverings with you, have sanitizer with you. I always carry plastic gloves to give to my buyers, but you have to be responsible for them. And because sometimes they're not responsible enough. If there are children, they have to be wearing face masks also, unless they're just too young to keep them on. Practicing social distancing by keeping at least 6 feet away from your, so you as the buyer would keep 6 feet away, you as the agent would keep 6 feet away from the buyer. Avoiding touching knobs, faucets, toilets, toilet handles. This again is to the buyer. Light switches, garage door opener buttons, handles and pulls, alarm system controls, fan, and so on and so on. So when I take a buyer to a house, I tell them that I will open things for them, that if they want something open, to please wait, and I will do it for them, because I am wearing plastic gloves, and I always make sure I'm washing my hands and sanitizing them. And I would suggest you do the same thing. Do not let them touch things. You know how safe you are. You don't know how safe they are. Signer acknowledges and authorizes authorizations. There can be no written materials or brochures of the property. So should there be, don't let your clients take them. And that is definitely a problem for the seller's agent. They should not have anything there. A set of rules for agents, right? There'll always be something posted at the front door. It's a danger thing or caution or something like that, saying, you're entering at your own risk. Signers acknowledge that already others have been advised to clean and disinfect the property before and after each showing. Even though somebody is supposed to be disinfecting the house after each showing, that is not happening. When I have listings, I can't possibly get over there after every showing. And so I have disinfectants there. I have paper towels there. I have a disinfectant spray. And I say, please, in my confidential remarks to the agents, to please clean, disinfect the property, everything you've touched upon leaving the property. That includes the lockbox. Those lockbox, they are dirty. Make sure you take some kind of a sanitary wipe and clean it off before you touch it. The keys are dirty. Remember all those tiny little things that you aren't going to want to do, but it's for your protection. Let me see. Signer has been provided an electronic copy, right? Because they'll be signing it electronically more than likely. And signer can obtain online information about COVID directives from this site down here. So, and they have a copy of this, so they can just go right to that site. Signer representation. You understand that accessing the property for any of the purposes above may be dangerous, unsafe, or could expose you to or others to COVID-19. To the best of your knowledge, you are not currently infected by COVID-19. To the best of your knowledge, you are not knowingly within the last 14 days been in contact with someone with COVID-19. You are not experiencing a fever, a sign of respiratory illness, and so on and so forth. You understand that persons may be afflicted with COVID-19 and not exhibit symptoms. Those are your, you will obtain broker, you will inform broker if any of the data in this document is signed, there is a change in your health condition or knowledge that potentially puts others at risk, or validate the representation made in this document. So this is really interesting, because let's say somebody went into the property before you, a day or two before you, now contacts their agent and says, I was diagnosed with COVID. You don't know it yet. You went in, they were infected. And that is why it is so important that you use these PEADs and send them off to the seller's agent. You need to, every time you go in, you can't rely on just one form for every time you go in. You have to do a new one each and every time. And then down below, like I said before, the signers will be initialing. Accompanying minors, this is where their names will go. You will say minors, colon mark, and then their names, because they are allowed in. They didn't used to be allowed in when all this first happened. Agreement, declaration, and assumption of risk. By signing below, you are declaring the foregoing to be true, that you agree to take all recommended and reasonable actions to protect yourself and others from exposure of COVID. You understand and agree that no one, including but not limited to real estate brokers and agents, can guarantee that you will not be exposed or contract COVID. And then they have to sign below. So the buyer will sign, you have to check mark. Buyer will sign, you have to check mark. Buyer's agent, you are a broker or agent, you have to put your DRE in. Now, let's say you're bringing in an inspector because the inspections haven't been done, or you want to do further inspections. You'll have a whole new form. They will be other entrant. It'll be their name, their signature, and other entrant. You again as the broker with your DRE number. So every time you go in to the property, you have to have one of these forms and fill it out with the proper checkbox. And then down below, broker agent for the buyer, you will initial down here. It's not a, it's an optional initial. We like it if you do it, but we can't mandate that one because it comes off as optional. So are there any questions on this form? I'm not seeing hands, so you'd have to speak up. Okay, I will go on.
One thing, Pat.
Yeah.
Even though you can let children in now, I never let children in because you can't control them. They run around, touch everything. Their parents never control them.
Okay, so right, I have a talk with the parents before the children go in. I have one couple that has one child, and I tell them she can't touch anything. She can't even touch the walls. So just keep her really close to you. And I'm also not very concerned about the walls. I'm more concerned about the light switches, the doorknobs, because that's what everybody wants to touch or to open things up. But I agree with you. I would prefer not to have children. It's hard. It's a difficult thing to say, sorry, your child can't go in. So one of you gets to go in at a time. And I know they like to go in together. It'll be your call on that one. I think you can kind of tell the behavior of the child before you step inside the house. This one here, property visit and open house advisory. This one is a very new form, and I like it because it's going to be a form that we're going to be using when we're able to do open houses again. Therefore, everybody's going to have to sign this form when they come in, and I love that. Anyway, recording devices. This is why one of the reasons we have to have this is because you know that Amazon Ring, the doorbell, that has, it takes a picture of you. I mean, it has your picture. You can see who's coming in. And some people have cameras inside the house and outside the house. They're supposed to, listing agent is supposed to put that in the MLS. Sometimes the listing agent doesn't know it. I didn't know it once. I did not go in the MLS, even though I knew about this form. I did not know they had cameras. So always assume that there's a camera in the house watching you and listening to you. So watch what you say. Like, especially as agents, don't say, well, I have a feeling that they'll take less money for this, that kind of thing, when you're inside the house, because they're hearing you. And they're going to remember you. I would try not to talk about things like that, or about how disgusting the house is. Like, you can say how beautiful it is, or look at what, in an ugly house, you could say, well, look at what you could do with this room, or look at what you could do with this wall. You could maybe take it out, that kind of thing. You can say things like that without nasty words about the house. Let me see here. Visitor safety. Visitor is advised to be aware and watchful of conditions on any property. Visitor is most likely to be unfamiliar with the property's terrain, layout, elevation. And so that's like outside. There's a lot of uneven pavement out front and out back that are trip hazards. And so you have to watch out for those. And again, if you're going to walk on any grass has dips in it that you can't see, or the land does, the lawn, and you can't see those. And people can sprain their ankles by stepping in one of those lower spots. Stairways, carpets more. It's carpets that sometimes are lumpy. They've stretched out and they get lumpy. People can trip on them. They can trip on rugs that are on the floor. So this is what they're supposed to be careful about. This again is to the buyer. Animals and pets. Visitors advised to use caution around animals and pets, right? You don't know their temperament. Accompanying minors. Visitors advised to watch any accompanying minor. Visitor is responsible for their care, safety, and conduct in the property. Risk of injury. This is good. Upon entering the property, visitor acknowledges the risk of injury resulting from unfamiliarity with the property. Visitor is advised to exercise caution. Visitor agrees to assume the risk of entering the property. So that, I really like that they assume the risk. Any questions on this form?
Yeah. Hi, Pat.
Yes.
Yeah.
Who am I
So
talking
we,
to?
this is Ambreen.
Okay.
Okay. So we do not need to upload this form on the command, right? Since this is not applicable right now.
You do need to, because you're doing a property visit.
Okay.
This is a mandatory form in Cote command.
Okay. Got it. Thank you.
It is, I think it's going to remain there forever because of the open house part of it.
Pat,
Wait a minute,
Yeah, who's this?
Pat, you're saying that
Wanda.
every time a visitor goes into a house, we need them to have signed this also?
No, 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 no. If that was the question, I'm sorry. This is a one-time only form for your buyer because there's no address on it.
Okay, do we need to put that in command?
Yes,
Thank you.
that'll
If
have
they
to go
want-
in command with the property you go into transaction with.
So every buyer from now on, we should have them sign this form and put it in command.
Yes, you
Thank you.
should, and yes. And this will also be for open houses. So if you're doing an open house, you're gonna have to put every one of those into, you'll have to save them. You know, you'll have to download them and save them into a folder somewhere. Any other questions?
Yes, Pat.
Hi, Pat. Pushpa
thank
here.
you for-
Wait,
This
I've
is-
got another person talking, Pushpa. What?
Okay.
This is Anda. That was my
Okay.
question as well. This is one-time signature, but going back to Pete, sorry, I didn't bring that up earlier. When you said that there are multiple addresses that you can enter in the beginning, are you sending to listing agents that Pete showing different addresses?
Yes.
Thank you.
Yes. They don't care. Or I
And
don't care.
It's proper. It's properly done. If you decide to go with one property, make an offer, that's gonna stay in the file. I don't have to make a new one that's just for that address for the transaction's sake.
No.
Wait a
Once you
minute,
get it,
Pat,
okay, so once you get into contract, then you'll have to do a PED for that specific property every time you go in.
But don't you have to type that address on? If you're gonna do multiple properties, you can't say multiple properties. You have to type each address in you're gonna go see.
Oh, yes, you have to, do not say multiple. Oh, type in the address. Oh my gosh. Otherwise, we won't know where you went in.
Yeah. So on that form that in the beginning, that you had multiple properties, you meant type in the addresses.
Oh, I'm sorry. Yes. Thank you for clarifying that for me. That was a mistake on my part to do that. I should have put in 3 separate addresses. Any other questions?
Sorry to go back to that. If there are no consecutive visitings because it's a non-contingent offer, that would suffice. That bid with multiple offers.
Don't understand your question. Say it again.
If there are no other visits after the offer is accepted with that PID that has multiple addresses, we don't have to make another PID just for that specific
No,
address.
only if you're going to go into the property. That includes final verification.
Final verification. Got it.
Right. So we always expect to see 2, but that's not always the case, right? It might just be the one with the 3 addresses, 4 addresses on it. But we will question you, no doubt about it. We question people a lot on the PEDs. Oh my gosh. Oh, and one other thing, a little heads up that every property you show these people, save those PEADs because we want every one of them, every property you showed them, they have to be uploaded. We have to have a copy of every house PEAD for each entry of every house.
And when
Questions on that?
when do we upload those?
When you go into contract, they would all go under the property that you're in contract with.
Got it. Thank you.
Okay. Any other thing? Or if not, I'm going to go on to the 3rd form.
For the other form, the second one,
Second one we just went over. That was property
Yeah.
visitation.
and for that one, for the open house portion, every person who comes in to the open house needs to sign this.
They're going to have to. Right. Well, I think we're going to know more as we get back into open houses. Steve will probably talk to us about it. Right now, I see me having this open house advisory. Many of them at the property.
Mhm.
But I don't know. I'm just expecting that to happen. But Steve will have the final say. He's the broker.
Okay.
Okay, anything else?
So Pat, what happens even after signing the open house advisory form? If somebody gets hurt, what will be the course of action?
Not a clue. Not a clue. They're supposed to be assume the risk. That doesn't mean they don't sue the seller. But I can't say what will happen if they get hurt. Yeah. It all depends on how much they believe this form. And how much you've told them. You know, by going in here, you're assuming the risk of entering the property. So do your due diligence and explain the form to them. Tell them how important this form really is. Just make sure that they sign this form at least, or they have to sign it one time. Okay, can I go on, or you want any other discussion?
I just have one comment. I remember Pat giving me advice to make like little notes for your clients. So you can put that into DocuSign. And so they know exactly what is what the, the property form is about. And then you always want to make sure to read.
In the message,
Yes.
area, yeah.
So that way you don't have to explain it to them. You can just have them read it.
Right.
Make it a little easier for you.
Right, I tell them what's in it, right, and then I expect them to read it, and then I always say, remember to read before signing. Always read before signing.
Yes.
I want to take that responsibility off me and put it on them. So I say, always remember to read before signing. That's I think it's a great little sentence to put into every e-signature signing. Any other questions? If not, I'm going to go on. The next couple of forms I know very well, but then I'm coming to some that are brand new again. So here we go. Is it big enough for you guys?
Yes.
Okay, I don't hear you all very well, but I'm going to, hopefully everybody says yes. So this one here is the agency relationship. This is a mandatory form that on the top of some of you haven't seen a transfer disclosure statement yet, the real estate transfer disclosure statement, but in the very top paragraph, it talks about a code. That is this code. It's referring to the real estate disclosure regarding real estate agency. And so you have to fill that out and date it so that they know, we all know that you have discussed this form on that the TDS is like a disclosure saying, yeah, we did. So you would check this box if this form is being provided in connection with the transaction of a leasehold interest exceeding 1 year or a civil code, blah, blah, blah. I've never seen this box checked yet, so I don't expect to see it very often. When you enter into a discussion with real estate agent regarding a real estate transaction, you should from the outset, understand what type of agency relationship of representation you wish to have with the agent in the transaction. Remember, they're always talking to the buyer. So are you going to be representing the seller only? Are you going to be representing the buyer only? Or are you going to be representing both buyer and seller? So the duties are the same for the seller and the buyer's agent. It's your fiduciary duty of utmost care, integrity, honesty, loyalty in dealing with the seller. To the buyer and the seller, say exactly the same thing. Diligent exercise of reasonable skill and care and performance of the agent's duties. A duty of honest and fair dealing and good faith. A duty to disclose all facts known to the agent materially affecting the property or desirability of the property that are not known to or within the diligent attention and observation of the parties. An agent is not obligated to reveal to either party any confidential information obtained from another party that does not involve the affirmative duties set forth above. So this is very interesting because I'm hoping, kind of hoping, that I have this listing in San Jose that's coming up. A part of me wants it and a part of me doesn't want it. he and his neighbor have restraining orders against each other. So that, of course, has to be disclosed. That's one of these things where I know I wished he wouldn't have told me quite so much, but he did. And the neighbor exposed himself. And so that becomes now a material fact, and one that the buyer will have to know. So I have a feeling no buyer with a child is going to ever want to buy that property as long as that neighbor is there. So be careful with what the seller, you just want to know as much as you need to know. And for this one, they can go to the courts and find the things that were filed, the forms that were filed, to see what the restraining orders are about. But now I have to disclose it to the next buyer. Anyway, so if you're representing both buyer and seller, a real estate agent, either acting directly or through one or more salespersons or broker associates, can legally be the agent of both the seller and the buyer in a transaction, but only with the knowledge and consent of both seller and buyer. In a dual agency situation, the agent has the following affirmative obligations to both seller and buyer: the fiduciary duty again, and other duties to the seller and the buyer as stated above in their respective sections. So those same things. And in representing both buyer and seller, a dual agent may not, without the express permission of the respective party, disclose to the other party confidential information, including, but not limited to, facts relating to either the buyer's or seller's financial position, motivations, bargaining position, or other personal information that may impact the price, including the seller's willingness to accept a price less than the listing price, or the buyer's willingness to pay a price greater than the price offered. Be careful what you say. When you're in a dual agency, be careful what you say to the buyer, because the seller is going to tell you things. One of the things I always ask my seller is, can I tell the buyer why you're selling and where you're going? Because that seems to be their number one and number two questions. Why is he selling? Where are they going? And I would like to be able to tell them. And I usually get a yes from the seller, that, yeah, you can tell them that, I don't care. But they always want me to be vague, like they're moving to Stockton or moving to Sacramento, and without much else involved in it. And if they say something like, well, I can't stand my neighbor and I have to get away from them, I choose usually not to tell the buyer that, right? Because, it's, or you can just say, there were just some personality conflicts going on here, or whatever the seller has allowed me to tell them. Either, let's see, seller and buyer's responsibility. Let me see what all of this I need to do. The above duties of the agent in real estate transactions do not relieve the seller or buyer from responsibility to protect his or her own interests. You should carefully read all agreements. If you are the buyer, you have the duty to exercise reasonable care to protect yourself, including those facts about the property which are known to you and within your diligent attention and observation. Strongly consider you should be talking to a tax advisor. Anyway, get legal counsel if that's what you need, because we are not tax people, we are not professionals, and we are not professional lawyers. So don't tell them things that you aren't fully informed on. Throughout your real estate transaction, you may receive more than one disclosure form, depending on the number of agents assisting in the transaction. So that happens with Carl Medford's team. There's always two people on a transaction. The law requires each agent with whom you have more than a casual relationship to present you with this disclosure form. You should read its contents each time it is presented to you, considering the relationship between you and the real estate agent. The disclosure form includes the provisions of section Civil Code set forth on page 2. Read it set forth on page 2. Read it carefully. Acknowledge receipt of the copy of this disclosure. So again, here it will be, you always mark a box. I don't know why seller is highlighted, but you would always mark the box and who the buyer is, who the seller is, and your name, and the real estate company's name, and the agent, real estate company's DRE number, and the agent's DRE number. Memorize your DRE numbers. Then here are all those civil codes on the back, on page 2. I hope someday you read this. I know you aren't going to read it right away, but I hope someday you will read page 2 of this form. Let's see here. Any questions on this one?
You said that a team, in the case of
that's
a
what
team, 2 people, they have to fill out 2 of these?
I don't know. They don't have to fill out 2. Let
You
me
said
see.
Carl Medford's team, they get 2 of them
There's always 2 people. There's always 2 people.
that are representing
The
the
buyer, the
owner.
buyer,
Okay, say the buyer. Why are there 2 people representing him?
because Carl is always one of them. And then whoever he has assigned to be the buyer's agent is the second one.
So if you have a team and you also represent the buyer, and then your member of your team does, you have to provide 2 of them, is what you're saying.
Well, this disclosure form includes the provisions of section 207913. No, they never do 2 of these, like, they never do 2 of these, inclusive of the civil code set forth on page 2. Read it carefully. We acknowledge receipt of a copy of this disclosure in the portion of this book. So where did I read that? Throughout your real estate, the law requires each agent with whom you have more than a casual relationship to present you with this disclosure form.
The
You should
number
read
of
its
agents
contents each time.
assisting.
Say it again, Jerry.
It's the number of agents assisting in the transaction.
Yeah,
Whoa. So
yeah.
that
I
could,
have to clarify this, guys, because we never get 2 of them.
Actually, I have a
That's-
comment if I can.
Sure.
Whenever Alex and I represent the same client, we usually put either my name or his name. I guess we only need one. That's the way that we've always done it for the form.
But you're, both of you are assisting, like both of you are signing the contract?
Yeah, but we only
Well,
need one.
But that's,
So
but therefore,
it's just the main listing agent or the main agent that's involved. And then
That's
there's
what you
another
think?
disclosure. Yeah, and then there's another disclosure to disclose that there's another
Yes.
agent involved as well.
right, there is another disclosure for that.
Yeah.
And maybe that one will take care of this one. I hope I have it in here. We'll look at it today. I'm
And then
sure I have it in here.
also, I'm not sure if you already went over the cover sheet because that makes everything a little
No.
easier. So you have to input everything one by one, just like their name, the company name, and all of that.
No, because it's not a disclosure, so I didn't want to do the cover sheet.
Oh, I see.
It's just a
Okay.
disclosure class, yeah. But I still want to check in on this. I want to make sure that the additional agent acknowledgement covers this. Right now, I'm going to say you only have to have one of these.
that's what I thought.
If there might come an email out from Steve saying differently. Right now, I'm going to say you only need one agency disclosure for Keller Williams. This one was actually the one, I'm going to show you this also. Oops, let me see here. Here we go. So you see this seller's brokerage firm to the seller.
Yeah.
So that's why I had Compass on there. Here is this one. This is the one that will come in the purchase agreement. Seller, our buyer's brokerage firm to the buyer.
See what it says down there.
Yeah, I'm going to. This is exactly the same thing. So let's see what it says down here. The law requires each agent with whom you have more than a casual relationship to present you with this disclosure form. You should read its contents each time. Huh.
That doesn't say, it says you may receive more than one disclosure form up above that, the line above it in that paragraph.
Let's see, throughout your real estate transaction, you may receive more than one disclosure form, depending on the number of agents assisting in the transaction. Huh. Let me,
Isn't that funny? We learn something new every time we do this.
really, I've got to highlight this so that I don't forget it.
Yeah.
Whoops.
Also, in the case like you were explaining earlier, where they told you about the next door neighbor and they had a restraining order, and then they told you why,
Yes,
that is dynamite. At
yes,
that point, you should talk to Steve and say,
I did.
how do we,
I did.
how do we handle this?
It
And
was interesting. He said, you have to be very honest with that one. He said, do not advertise it in the MLS. He says, put it in your disclosures.
yeah,
He says, if you advertise that in the MLS, he says, you will have eliminated 60% of the buyers.
so what you should say though is I've been advised by the seller of this property that this occurred. Not,
I will not say, I will let the seller write that, not me.
you have knowledge.
I have knowledge. I'll make sure that that knowledge goes on his disclosures.
As long as it's on his form, I think it's fine, yeah.
Right, it will definitely be on his forms, and the restraining order number and things like that will be in there in his disclosures so that the buyer can look it up.
I had a nosy neighbor one time down the street that came up and told me that somebody hung themselves in the garage.
Oh,
But it was hearsay, so I didn't have to carry it. any
oh,
further.
really? That's good. So I wanted to show you one more form, guys. It's the same form. And this one is the selling firm. That's the buyer. They haven't changed all the verbiage in these forms yet. So selling firm is the buyer's firm to the seller, not the seller's firm, but the seller. This would be used, best of my knowledge, in a for sale by owner. Because you would want this for sale by owner to know that you are representing the buyer, the selling firm, right? The buyer, and they belong with Keller Williams. Questions on that? Otherwise, I can't think.
Part of that's covered now in the in our RPA.
Yes.
Because
Yes.
they make they acknowledge who they're representing. And
Yes.
also it says you have received disclosure regarding real estate agent
Right.
relationship. So
Uh-huh.
I think this form may.
This might become obsolete, right, and not be there anymore.
Yeah.
But they just revised it in 2018.
Yeah, I don't mean to interrupt. I apologize.
Okay, so possible representation of more than one buyer or seller, disclosure and consent form. This form is telling buyers that the broker has many buyers, that you are not the only buyer that Keller Williams is working with. And other buyers may be seeing the same property that I'm showing you. And we also have many sellers. And we may be showing you property that our office, our Keller Williams Benchmark Property Office is representing the seller. So therefore, Keller Williams is representing the buyer and seller. And that would be your dual agency. But just to let you know, Mr. Buyer or Mrs. Buyer, that you are not Keller Williams' only agent or only client. We are working with many clients. And that is apparently a lawsuit in the past, or this form wouldn't be here. Somebody probably said, you didn't tell me you were working with a bunch of other buyers, like you yourself might be showing that same home to multiple buyers, you as an agent. Now, and here's another little clause in here. Offers are not necessarily confidential. Let me enlarge this. There, buyer is advised that seller or listing agent may disclose the existence, terms, or conditions of the buyer's offer, unless all parties and their agent have signed a written confidentiality agreement. Whether any information is actually disclosed depends on many factors, such as current market conditions, very important for this area, the prevailing practice in the estate community, the listing agent's marketing strategy, and the instructions of the seller. It is current market conditions in the Bay Area to not disclose the terms and the price and whatnot of incoming offers. It doesn't make it illegal. Like if the seller wants you to do it, you can do it. It's something that I don't discuss too much with my seller, because they would say, sure, tell them, because maybe I'll get higher offers, that kind of thing. And it's not something that our area does. So I go over this a little bit with them, but it's just touch on it and that's it. And that's it. Is there any questions on this form? We call it the disclosure and consent form. No questions? This next form is going to take a while to go over. It's a new form. This is the first time I'm teaching it, so I have read through it maybe 3 times.
Pat?
Yeah.
What point do you give them these forms?
Oh, when, okay, I'm going to tell you at what point you should give them these forms, okay? So the agency disclosure is supposed to be given to them immediately. I don't give it to them till I'm writing an offer because it's part of the offer. I do give them the PEAD-V and the open house one, the property visit open house form. Those are the only 2 they get from me right up front. But you should also be giving them an agency disclosure so they know who is representing them. Okay, fair housing and discrimination advisory. This whole thing, I couldn't believe all the stuff this form has in it. It's just incredible. Equal access to housing for all. All housing in California is available to all persons. Discrimination, as noted below, is prohibited by law. Federal state law prohibits discrimination against identified protected classes. Here are your identified protected classes. Race, I'm going to go this way: race, sex, marital status, citizenship, criminal history, non-relevant convictions, color, sexual orientation, familial status, family with a child or children under 18, primary language, ancestry, gender, source of income, whether they're a Section 8, immigration status, national origin, gender identity, disability, mental or physical, military veteran status, religion, gender expression, medical condition, age, and any arbitrary characteristics. Those are all protected classes. And the Federal Fair Housing Act, FHA, prohibits discrimination in all parts of real estate. Federal Fair Employment and Housing Act, the FEHA, prohibits discrimination on sales, rentals, financing, opportunity against persons, and protected classes. The California UNRU, I don't know how to pronounce that because it's an acronym. UNRU, pardon?
It's
Civil
not
rights.
an acronym. It was a
Oh, it's not an acronym?
no, the Unruh, Jesse Unruh.
Oh,
Yeah, he was a politician in California, actually, Jesse Unruh.
oh, well, that would make sense. He's from California. Yeah. Prohibits business establishments from discriminating against and requires full and equal accommodation, advantages, facilities, privileges, and services to persons in protected classes. Americans Disability Act, same thing, discrimination based on disability and public accommodations, other fair housing laws. Then it goes on, and then potentially legal remedies for unlawful discrimination violation of fair housing laws may result in monetary civil fines, injunction relief, compensatory and other punitive damages, and attorney fees and costs. And I got a really important one down here. The California Department of Real Estate requires training and supervision to prevent housing discrimination. Realtor organizations prohibit discrimination, NAR Code of Ethics. Who is required to comply with fair housing laws? Sellers, real estate licensees, mobile home parks, insurance companies. Mobile home parks aren't very good at that. I think they have a lot of room to grow there. Landlords, real estate brokerage firms, homeowners associations, government housing services, sublessors, property managers, banks, and mortgage lenders. And then examples of conduct that may not be motivated by discriminatory intent, but could have a discriminatory effect. prior to acceptance of an offer, asking for or offering buyer personal information or letters from the buyer, especially with photos. Those types of documents may be inadvertently reveal or be perceived as revealing protective status information, thereby increasing the risk of actual or unconscious bias and potential legal claim against sellers and others by prospective buyers whose offers were rejected. Do not give a letter with a picture. Don't show your sellers letters from buyers with pictures. This comes into play. Don't do it. Refusing to rent an upper level unit to an elderly tenant out of concern for a tenant's ability to navigate stairs in a house with a pool to a person with young children out of concern for the children's safety. Can't let these things affect you. If they want to buy the house, they buy the house. Examples of lawful or improper conduct based on a protective class or characteristic. Refusing to negotiate for a sale, rental, or finance, or otherwise making housing opportunity unavailable, failing to present offers due to a person's protected status. When we're done with this class, I want you guys to read this form again. It has unbelievable information in it. Refusing or failing to show, rent, or sell, or finance housing, channeling, or steering. Don't ever do steering. A prospective buyer or tenant to or away from a particular area due to that person's protected status or because of racial, religious, or ethnic composition of the neighborhood. When somebody asks me, is that a good neighborhood? I'll say, you know, all neighborhoods are good to some extent. Some neighborhoods are better than others. And what I suggest that they do is drive a neighborhood at night when it's dark. See what the streets are like at nighttime. See who's outside, see if there's crazy driving going on. You can look into the city crime files, police files. I think there's something that's very open to the public, and see what kind of crime goes on in the neighborhood. I'm not going to tell them. They have to do that research themselves, because that would be steering them away or channeling them to another area. Blockbusting or causing panic selling by inducing a listing, sale, or rental based on the grounds of loss of value of property, increase in crime, or decline in school quality due to the entry or prospective entry of people in protective categories into the neighborhood. Making any statement or advertisement that indicates a preference, limitation, or discrimination. Now, I don't even know what all of this means. Making any statement or advertisement that indicates a preference. You know, I think of how we write in award-winning schools. I still think that's okay. But that's such a broad sentence to me. Anyway, inquiring about protective characteristics, such as asking tenant applicants if they are married, that kind of thing. Using criminal history information. Anyway, I'm going to not read every one of these. Denying a home loan, offering, harassing a person, right? Examples of positive practices. Oh, I like this. Real estate licensees working with buyer or tenants should apply the same objective property selection criteria, such as location, neighborhood, property features, and price range, and other considerations to all prospects. These are the good things, guys. Be courteous. Sharing information and offers of assistance to other clients and prospects. Housing providers should not make any statement or advertisement that directly or indirectly implies preference, limitations, or discrimination. Housing providers should use a selection process relying on objective information about prospective buyer's offer or tenant's application. Then we have your fair housing resources. Here's a bunch of websites you can go to. Limited exceptions to fair housing requirement. Please promise me you'll read this form. It's just, I will probably read it again, even though I've read it. I read it at least 3 times, but I might read it again because it has so much important information on it.
Can I make a statement about this, Pat?
Which one?
This form and discrimination. At one time, my office, you know, I had an office in Hayward for 23 years. 2 or 3 times during that time period, we had people coming in testing us as to whether we were going to discriminate against them or not. And so we have to be careful. There are people out there that will show up and will test you just so that they can file a complaint.
Huh, I wonder if I've ever been tested, like at an open house.
Well, if you don't discriminate, you probably would never know.
Right, yeah,
We never discriminated, so we didn't know. But I knew who they were. I could just tell by the way they were acting and
yeah.
what they were demanding.
Yep, we always, when I worked at a bank, we always knew when the bank auditors were there. They looked different. Anyway, so now we're going to go on to the California Consumer Privacy Act and Act Advisory.
Hi, Pat, it's Anda.
Yes,
I have a question about fair housing. If you do receive an offer with a love letter or seller letter, what do you do?
don't show it to the seller. You can tell them a letter came, we're no longer allowed to show these. And yeah, I would actually call the agent that sent it and tell them you're not going to present that letter because it's no longer allowed. It's in the Fair Housing Discrimination Advisory.
Thank you.
Yep. But do not show it to them and tell them why.
I thought it was only with pictures.
No, that was letters and or pictures. Okay, let me see here. We will go over that highlighted area again. See, I knew I'd get questions on it. Prior to accepting an offer, asking for offering buyer personal information or letters from the buyer, especially with photos. So it's letters and then especially with photos. Okay. So California Consumer Privacy Act. After this, it's going to go, I know the forms much, much better and won't have to read every little thing. So this talks about how the buyer's information can be sold to a third party. And then they start getting emails and things like that. Now down here, it was interesting. Most most MLSs will not be considered a covered business. Instead, the MLS may be considered a third party in the event a covered business exchanges personal information with the MLS. Under here, whether an MLS is a covered business or a third party, you have the right to be notified upon sharing. So the seller, this is the buyer and seller form. The seller can say, I don't want my property on the MLS because I don't want all this stuff coming to me. I don't want the phone calls and I don't want the emails coming out to me. The problem is that it'll be harder to sell their home and they probably won't get the best price. Now, talking about this, Keller Williams, because we're such a large corporation, or we has enough agents here, we do not opt out of this. We are a part of this covered business. And I want to show you another form, the SELM, which I was not going to go over today, but if I can find it. Additional agent acknowledgement. Sorry, I should have put it up front. Here we go. Oh, I just found it. It's at the bottom. Here we go. SELM. Here we go. So I ended up calling Bay East. And here it says MLS has not adopted the National Association of Realtors Clear Cooperation Policy. They have. This box, if you're using Bay East, and she said almost every Bay Area MLS has adopted it, you would not check this box. You would instead check something down here if you're not going to put your listing on the market within like 24 hours. But I just wanted to tell you that Bay East has adopted it. They do not sell the information. Don't want to touch any more on that form. Okay, that was just wanted to let you know that there's another form that kind of goes along with this one. So any questions on this? I didn't go over it very well. I find it a rather boring form, but it's a necessary one, I guess, because sellers might not want their information out there. Jerry, Alam, you guys have any questions or anything you can add?
I have a comment. Most of the time you see in the MLS, well, most of the time you find out that the seller does not want this in the MLS. The seller probably did. It's the agent that didn't want it in there. They wanted to try and double in the property themselves.
Well, yeah, that's,
Very few sellers really don't want it in the MLS. They're crazy not to have it in there. The only exception would be somebody that has a status that's well known, or like an actor or somebody like that.
yeah, yeah, yeah. But Brad, I think agents get in the way of transactions a lot.
Oh, all the time.
Right, when there's problems going on, it's probably the agent that is causing most of them. If there's some issues going on with the transaction, Elizabeth knows this.
Yes.
Anyway, yes. But it was, yeah, hers was an agent issue, not her, another agent. So I'm going to go on to the buy.
On the other end that was causing the issue.
Yeah, man. Buyer inspection election. This
Pat-
is like such a fun form. Yeah.
If it's not in the MLS, is that called off-market property?
Yes, it is.
Okay, thanks.
It's an off-market listing. And you have to have the paperwork to substantiate that. There are special forms that seller would have to sign because you want to, it's called CYA. Yeah, cover your ass. You don't want that seller to come back and say, I didn't say that. So in the listing agreement, you would put words that say seller does not want this on the MLS. And I think it already has some places in there for that. Importance of property investigation. This is the buyer inspection election. They have started numbering these. And I recently have realized why we now need numbers, because I had 2 of these come through. And how would you know which one overlapped the other one, really, especially when some agents don't have their client's date. So anyway, number your BIE, this is called. And then there's always an address on it. The importance of property investigation. So it is very important that the buyer do their investigation of the property. Even if they have received inspections from the seller, they still have the right to do their own. And they should do their own. The buyer's rights and duties, you have an affirmative duty to exercise reasonable care to protect yourself. Oops, let me get that larger. And to investigate and verify information and facts that you know are within your diligent attention and observation. The agreement gives you the right to investigate the property. Now, sometimes if you remove all your contingencies at the beginning when you write your offer, you've lost that right. You can no longer investigate unless the seller will let you. But at that point, the seller can say, nope, you waived that, you waived it, you don't get to do it. Broker advice, you're strongly advised to investigate the condition and suitability on all aspects. If any box below is checked, buyer agrees to pay for the specified inspection unless otherwise agreed in the purchase agreement. Buyer is responsible for choosing the provider and ordering the inspection. If you do not specifically request a particular inspection, now you may do so in the future. I'm sorry. If you do not respectfully request a particular inspection now, you may do so in the future in writing. However, if your contractual investigation period has expired, seller may not allow the inspections at that time. So your buyer, so in this case, like if they do want to do some inspections, you working with the buyer will more than likely call the inspector and set up the investigation, set up the inspection.
So
I would never put it on my buyer to do that. I would tell them who I'm hiring, and if they don't want that person, like maybe they know somebody, I would absolutely let them use their inspector. And if they want to use their inspector, then I would have them call the inspector, not me.
be very careful which inspections that the buyer checks in here.
Yes, we're going to go over them.
With the contract to a lender, they may want to see that inspection and then may want to see a clearance.
Well, this form does not go to the lender, though.
No, it doesn't, but
No.
But it's part of the transaction and you got to be careful. That's all.
Yeah, in the contract, you've got to be really careful what you write and don't write. more about what you do right when it comes to inspections. You don't want to.
This
Anyway,
is-
so
This is
typically, no,
CYA for the brokerage firm.
so typically when the buyer would fill out this form when they're writing an offer. You don't do not send this form to the seller. I want to repeat that. Do not send this form to the seller. This is this is an in-office form only. And have the buyer go through there and say, which one of these inspections or how many of these inspections do you think you want? Now, they probably have already seen a general property because the seller did one, a pest, and possibly a roof. There might also be a sewer lateral one in there. The natural hazard disclosure report will probably be in there. So they already have some, and they've already read them, hopefully. If not, you have for sure. And they might then say, well, I still would like to see another pest report. So they will check wood destroying pest. They'll say, I don't need to see another general inspection. And you can advise them and say, I really did like that inspector's report. I thought he did a good job. He's asking for, what would he be asking for? Let's see here. He might ask for a roof inspection. He might say, I recommend hiring a licensed roof inspector. And so they're going to get a second one. So they would check the wood destroying pest box. And then they would go down and say, wow, I think I want to do a lead-based paint. And then you can say, well, the house was built after 1978. So there is not supposed to be any lead-based paint. So this one could probably be a waste of money for you to test the lead-based paint. I'll say, oh, okay, I agree. The plumbing. So the general property inspection really covers plumbing quite well. If they think they want a plumbing inspection, they can check the box. Same with every one of these. Square footage will come from the appraiser more than likely. Structural easements, foundations, and slabs. So if the general property inspection has said, ooh, this foundation needs to be checked by an inspector, by a professional foundation inspector, I would definitely have them check that box. I would say, I think you should get that one done because the general property inspection is saying there could be an issue here. And then they do want to have a roof one because the roof wasn't covered in here. Now, if they're in Oakland or I think it's Berkeley or Alameda, I think San Leandro now, and then all up in Contra Costa County, north of Berkeley, the sewer lateral is now expected to be done because the city says so. And that is typically a seller. A seller is going to do that one, and then whoever pays for it is negotiable. So anyway, they will go through every one of these to see what they want to have. And so that's fine. They can do whatever they want at this point. Okay, and then they will sign it. Now in your head, you're thinking, oh my gosh, I got to find a plumber to get out here. How am I ever going to get a plumber out here? And I better find a foundation person just in case they decide to go ahead with it. They're very expensive. They can range from $500 to over $1,000 just for the inspection, depending on what type of, or how easy it is to get into the foundation, things like that underneath the house. Anyway, but they get to check off whatever they want. And then we'll go on to the next form because we have a waiver for some of these. Any questions on that form? It's done right up front so that you know exactly what the buyer wants to have done, unless they waive all their inspections.
Yes,
So
I
on
do have a
this-
question,
Yes,
Pat. If there is an offer with no contingencies, are the buyers allowed to walk the property, even if it's just visit the property with no, or inspect it with no changes to the contract? Like we want to come in.
you have to get permission from the seller to do it.
Okay.
Yep.
So it's up to the seller to allow us
Uh-huh.
to visit, although it's non-contingent.
Correct. Right.
Mm.
Correct.
What
It's up to
are
the seller to allow it.
Mhm. Okay, they are not obligated to allow us.
Correct. Because you waived everything. You waived all those inspections.
Thank you.
Okay. So then that goes into the importance of investigation, the buyer's rights and duties again. Then we come down to the waivers, and like This is one of the hardest forms in zip forms there is to understand and remember. So let's say, we're going to start with number 4. Let's say the seller gave you some of these. They gave you a general home inspection and they gave you a wood destroying pest. So they gave you this one, they gave you this one. And what other one do you want? The roof? They gave you the roof? Sure, we'll write that in. They gave you the roof. Now you have to say who prepared it. So I'm going to say Home Guard. They're very popular. Home Guard. So you'd have to put in Home Guard. And the date they did the date that they did the inspection. So if Home Guard did the general property, they probably did the pest too. So we're going to just put it, they're not my, don't think that they're my company. I don't ever use Home Guard. You would put in the date for when they did the pest inspection. And the roof, again, they do all 3 for some bargain price. You would put in Home Guard. It's easy to use Home Guard because they're all the same name, and the date of the roof inspection. Now, so the buyer has been given these. It's not, these are not checked when the buyer does their own. These are checked when buyer has received from somebody other than them ordering the inspection themselves. And usually they come from the seller. Now up here, now does the buyer want to go ahead and accept this general property inspection report and say, you know, it was a good inspection report that seemed to cover everything and had good pictures and all that stuff. And so up here they might say, right, I don't think I want to do another one. So they would initial it. Broker recommends that buyer obtain a home inspection, even if seller or broker has provided buyer with a copy of the home inspection and obtained by the seller or a previous buyer. If you do not do so, you're acting against the advice of the broker. Buyer has decided not to obtain a general home inspection at this time. They would initial here if they're not going to do a second inspection. Because if you don't initial here, we are expecting to see one here, and we're expecting to see the second one that you order. Keep that in mind. If you don't initial this, and this is all filled in, we expect to see 2 inspections. So buyer has decided not to obtain one. We'll say that's good, but they did want to do another pest inspection. So here they will not initial. They'll leave that open because they want to do another pest inspection. And then down here, is there anything that you, the broker or agent, would recommend that the buyer decide to do? Now, do you want them to do a foundation inspection? Those ones that they checked on that other form? Do you want them to do a mold inspection? These will come from the general property inspection report as to whether there should be more, or from their property inspection report from both of them, if there should be more inspections done. You would want to recommend some or not. Down here, it says the reported disclosure recommends that these right here, they're talking about number 4s, the number 4 inspections, that buyer obtain special investigations. Broker recommends the buyer obtain those additional investigations. If you do not do so, you are acting against the advice of the broker. You're not going to do any additional investigations that these reports say you should do or recommend. They would initial here. If they do want to do more, they don't initial here. And then you will expect to see more inspections. Now, let's say, let me shrink this. We're going to go back here to the buyer inspection election. They've now seen all these. Now, which inspections do they want to do? So this will become number 2. Maybe they have now given up some of these ones that they used to want to do. And so now they'll just check the ones that they still want to do and go forward with what they want. And then you have to hire inspectors. So that's where this number is very important, because number 2 will overrule number 1. Got that? Everybody okay? Questions?
I'm
Okay.
not sure I understand where number 2 comes in.
Buyer, the BIE number 2? You mean number 2 up here?
Yes.
Okay, that is, remember on number one, they had checked a whole bunch of things. Remember that? They checked maybe 5 different things. We didn't check them because I can't, because it's all blanked out for me, so I can't check them. And now they decided they don't want to do all those 5. Remember, they don't want to do another general home inspection, but they still want to do a wood destroying pest, so that will now still be checked. Maybe they don't want to do a roof anymore, but they had it checked before. They had a sewer thing checked, but they don't want to do that anymore because of what the general property inspection said. You know, those kind of things. So now they're only going to want 1 done. And so this will become the buyer inspection election number 2. They will want 1 inspection done besides the ones that they have already received. This one will now overrule number 1, and we will expect to have 1 more inspection, and that'll be the one that the buyer hires.
Okay, thank you.
Got it?
I do have a question, please.
Okay.
If
On which form?
a buyer inspection waiver always goes with the offer?
What's the question?
Buyer inspection waiver, is
Yeah,
that
here we go.
always goes with the offer to the seller?
No, no, none of these do. See, the seller doesn't even sign these.
Oh,
Do not send these. Do not send the buyer inspection election or the buyer inspection waiver. And I'm not going to go over the Keller Williams one because I don't know if we have people here from other offices, because they would not have that other form. The Keller Williams buyer inspection waiver. I don't even know if I have it in here. Yes, we do. So does anybody want to see this one?
sure.
Okay, and I apologize to anybody who's in here not from our office. So the property address would go up here. And because the buyer inspection waiver only covered the general property inspection and the pest inspection and 1 other, they now have the option to waive other things. So they can now waive whatever they want on here that they had checked on the BIE, they can now waive it. So they would waive the roof. They would have to initial where everyone they want to waive. Let me see, let me read it, make sure I've got this correct. By initialing in the spaces below, buyer acknowledges the buyer has decided not to obtain the inspections, and unless buyer makes a subsequent election in writing during buyer's investigation period, if any, buyer waives the right to obtain the inspections. What we typically have everybody do is initial every one of these because they are waiving them. Everyone that they want to waive. If they're still going to do the roof, they would leave this one blank, but they would waive everything above it and everything below it. I want to talk to Steve about this form. I want to change it. And then the same is true over here. So what you could do is just put the initial, have the buyer initial here, draw a line going down, skip over anything that they want to have done so that they can initial there, and then continue your line on down. Because it becomes very confusing to see initials and initials and initials and initials, all these initials. We can't even tell what's initialed and what isn't sometimes. So what I prefer, just the initial at the top and then draw your line. Leave blank the one that you want to have done and then continue on with the line.
And this is
Okay.
done manually, like handwritten.
Yeah, you could, there's little tricks on the computer you can use.
I think you could change the wording to say that the buyer has decided not to obtain the inspections checked below.
I think it should go along with the BIE, that if they check the one on the BIE, that they want to have it, and now they're waiving it. You know, that's where I think they should do it. But I'm going to talk to Steve about this form. But right now, this is the form we have.
Do we really need this form since we already have the buyer inspection?
I feel the
waiver,
same way.
right?
Because we now
Yeah.
have that other BIE.
Just
Why do we even need this form?
Duplication, right?
Right. Anyway, I'll be talking to Steve about this
Sure.
and see if we can eliminate or make this form easier.
Yeah.
Right now, this is what we have.
So there will be 3 forms related to inspections.
Correct. There are 3 forms.
Thank you.
Okay. Now let's go back up to, we still have some really good forms we have to go over yet. Here, additional agent acknowledgement. This is where I feel the agency disclosure, that this would take care of the agency disclosure. And this is in addition, this is an addendum to the purchase agreement, because it defaults to the purchase agreement. And it has a buyer representation agreement or other. And it would have to be the purchase agreement. It wouldn't be to the agency disclosure. Because the purchase agreement has the agency disclosure on it.
I have signed this.
Yeah, I know you have, because Carl's team signs these, yeah.
Yeah, in that.
And the purchase agreement, you have to make sure that the date goes in here, the date of whichever one of these you're referring to, between the buyer and the seller. So whichever one you are, you're going to be filling it out, and the other party's name has to go in here. So if you are representing the buyer, when you get a seller, their name has to be typed in here. And they will then sign it. And it's multiple associate licensees working with seller or multiple associate licensees working with buyer. And the real estate licensees names below are all conducted real estate licensed activity under the same broker. That would be Keller Williams Benchmark Properties. And if there is a team, then a team would go in there. A team name. And then down here, the agents' names are listed. So it would be, we'll take Anda, it would be Carl Medford and Anda. And then your license have to go in here, and buyer just has to sign, and seller would have to sign. That's it. Yeah.
But it could be for co-listing, like Alex and Elizabeth.
Absolutely.
Yeah, this is actually the form that we signed.
Yep, this is
This
the
is the
form you would
exact
sign.
form. Yes.
Yes. If there's more than one person, you sign this form. And so therefore, I think it is the form that's okay for the agency relationship. But I will be finding out. Now, what else do we want to go over? These are your buyer forms that you need. These are disclosures that the seller gives you. Oh, here is another one that I want to go over right now. It's because it's another buyer form. It's this one. So nope, not that one. That one's for the seller. I wanted the one for the buyer. And I don't seem to have it. So I can't go over that form. Here we go. There, representative capacity signature disclosure for buyer representatives. So in here, this is a disclosure to one or more of the following: a purchase agreement, a representation agreement, or other agreement specified below. And here, buyer 1 and 2 is identified as buyer if a trust, this is important, guys, if a trust identify the buyer as the trustee of the trust or simplified trust name, and then they give you John Doe co-trustee or Jane Doe Jane Doe co-trustee or the Doe Revocable Family Trust. It not the name alone, John, whatever his name was, John Doe. It is never John Doe. It would be John Doe trustee. I see so often just the name go in here, and you can't. It tells you exactly what you have to do. Then you would, if it is a trust, you would then mark the trust, and then say what the name of the trust is, and if it has a date on it and things like this. Now, corporations can also buy. And I know Emron here in the office his name goes by Ron. He's an S Corp. So in this case, you would put S Corp. Maybe you're a corporation, a limited liability company, a partnership, or maybe you're a power of attorney. You are buying for somebody else that cannot buy for themselves. Maybe they're in another country. Maybe they have paralysis, whatever. But this would be, they have power of attorney over the person that's actually buying. Or it could be an estate. Didn't know an estate could buy. Okay, but an estate can also buy as a conservatorship, a guardianship identified by superior court name. So you'd have to have a little bit more information in this one if it's an estate that's buying. Down here goes the buyer, sign the name of the trustee. So it would be, the buyer is John Doe what is it? The Doe Revocable Family Trust. And then it would be John Doe Trustee, that Doe Revocable Family Trust. It would be her name, Jane Doe Trustee. Down here at the time of the sale, buyer, and so this would be the seller. In this case, I use Clayton Smith. Sorry, guys. Clayton Smith is the seller, are parties to a purchase agreement dated such and such from property known as this. And then he would sign as trustee, he would sign as the trustee. On this one, at time of buyer representation. So this is only if you're using a buyer representation agreement. Would this part be filled in by the buyer? At time of assignment or agreement, that's the only time you would fill out this part is at the time of assignment or agreement. That's it. So if it's not one of these two, you'll only be filling out page 1. It's a pretty simple form, actually. When it first came out, it was really complicated, and they've made it so much better. We are going to go on to
Question, Pat.
yeah.
So you're saying that you put in the name of the John Doe trustee in the very first paragraph.
Yeah, right here. Yep.
Who do you put in then as in the RPA as the buyer?
The buyer. Okay, so the buyer is the trust. If it's a trust that's buying it, and then you use this wonderful. Oh, I can't show you on this. There's this wonderful thing up here that you would use to use the person's name for signing, and it doesn't come up as the trust. But it's not showing on this one. Anyway, I can't show you. I can show you at another time, but I can't show you today because it's not here.
You understand?
If I back it up, I can show you, but I don't want to do that yet. I can do it at the end for anybody who wants to stick around. It's a wonderful, guys. When I discovered that, I called some transaction coordinators and they said, oh yeah, we already knew that. Just, oh my gosh, it was so fabulous. So the statewide buyer seller advisory. This is a mandatory form and it's automatically checked on no, it's not automatically checked. You should be checking it on the purchase agreement because it's actually a buyer form. Seller oftentimes has it in their disclosure packet, but it is an advisory. And advisories aren't a mandatory form unless you check it. I know I just said it was mandatory, but advisories are not mandatory. But if you put it in the purchase agreement, check the box, then it will become a mandatory form if the seller signs everything and doesn't counter it out. So here we have all sorts of things. And on this page, it tells you everything that's inside this form. What I want you guys to do, I really want you to read the form. It has easements, environmental hazards, formaldehyde, geological hazards, inspections, mold. Oops, I should get this bigger. Septic systems. There are septic systems. People still are using them, or at least they're on the property yet. Soil and geological conditions, square footage and lot size, water intrusion, well and water systems, wood destroying pest, accessory dwelling units, building permits, zoning, it goes on and on and on. California Fair Plan, future repairs, make sure you can always do remodels, especially if you're buying a condo. They might not let you do remodeling. Historical, if you ever are going to be involved with a historical sale or of any kind, listing or representing the buyer, wow, make sure you work with the city. There are rules when it comes to historical property. More rules than you even want to deal with. Insurance, land lease, marijuana, cannabis, and methamphetamine labs. And here I highlighted something, buyers advise that a property where methamphetamine has been produced may pose a very serious health risk to occupants. Buyers strongly advised to retain an environmental hygienist contractor or other appropriate professionals to inspect the property if methamphetamine production is suspected to have taken place. Broker do not have expertise in this area. All of the cannabis stuff, that's all legal. Marijuana, that's not an issue anymore. But this is still a big issue. Owner's title, renter and eviction control. If they're going to buy some rental property, make sure that they know all about the rules of the city and the county. Retrofitting. So anyway, it goes on and on and on, guys. Very, very insightful form for a buyer and you to know about. Notice of supplemental property tax. Make sure you tell your new buyer about supplemental property tax bill. They're probably going to get one if they're not paying all that extra property tax at close of escrow, because their property tax at the close of escrow is oftentimes set up with the previous owner's property tax. And maybe they were only paying $2,000 a year. And all of a sudden your buyer is going to be paying $11,000 a year. They are going to have to come up with $9,000 in supplemental property tax. No, not necessarily 9,000. The difference between what the seller was paying and what the buyer is paying. They will have to make up that difference. They can't be living in that property and owning it without paying the appropriate property tax. Learn about the supplemental tax bill. Tell them about it and tell them when they get it, they can call you and say, I think we talked about this, but I don't know what it is. There you go. Yeah.
Rent control and rent control is now a big issue.
Yes.
It wasn't in the past so much, but the laws have changed so much now that people think they can rent something out and then they find out there's all kinds of restrictions in what they can do.
Yep. And right now is really tough because if you are a renter, man, you can't evict anybody. If you are a landlord, I'm sorry, you can't evict people. The PACE loan, these were PACE loans were for energy and water conservation, remodeling, improvements to your home. They are a lien on your property, but that's what they are. They were for energy. Anyway, and then in your local disclosure and advisories, if you're the one that is initiating this form, whether you're buyer or seller, make sure that you add in whatever county it is. So I put this in brackets. It could be San Mateo, San Jose, or San Mateo, Santa Clara. It could be San Joaquin, whatever. County disclosure and disclaimer advisory. Any questions on this form? I know I went through it really fast.
Yes, I do have a question. When does the buyer sign this? And what do we do with it?
So if it's not, so first of all, you would open up the seller's disclosures, you know, in the disclosure IO or wherever they've got them. And you would see what's in there. And if they already have a statewide buyer seller advisory, then you don't need to do anything about initiating this form or even marking it on the purchase agreement, because if they've already signed it. If they haven't signed it, then you do have to mark it. So you got to look at those disclosures, see what is in there, and if the seller has signed them. And if the agent wants all forms signed at the time you're sending in an offer, you got to sign them at that time. If they say, wait until your offer is accepted and then sign the disclosures, then you do it that way. You have to read the instructions.
She was asking the question, when do you have the buyer sign it? My advice is when you're doing the buyer consultation with the buyer, you have them, first of all, sign a agency disclosure, and then you go over this form with them.
Yeah, that's good. Yeah, they can sign it immediately.
Yeah, that would be the best advice.
This is a very, and the county form, oh my gosh, it's even more powerful. The county disclosure and disclaimer. Let me go down to that. City of Oakland, Alameda County. I want to show you something in here. Look at right here, Meadowbrook Village in Fremont, page 18. You know, they've got that in this county form, page 18. So that if you're showing Meadowbrook, you better make sure you know what is going on in Meadowbrook. Okay. Make sure you know what's going on in Oakland if you're helping someone in Oakland, in Livermore. See, they have all these local city disclosures in here. Berkeley has a sidewalk repair. Oakland has a sidewalk repair, the sewer laterals. This is the Alameda County disclosure and disclaimer. Very important disclosure, guys. I wasn't even going to go over this one because it was so specific to one county. But any of you showing these properties know what you've got to do if they decide to write an offer.
Right now, more and more counties are doing this also.
Almost every county has one. There's a couple out there that still don't. The way I find out is I Google it. San Joaquin County disclosure and disclaimer. And if they have one, Calaveras County did not, I don't think. Elizabeth would remember better than me, but I don't think they had one.
Pat,
Yep.
Pat, if the buyer has already waived the investigation contingency, they still have to sign all of these, and they find
Yes.
something in here, they say, oh, I don't like this in this county or whatever. Like
Well, they've got to read these forms before they remove all contingencies. Oh my
That's
gosh.
why I say go over these first with the buyer before you write the offer.
Yeah,
Write any
absolutely.
offer.
Right.
Before you write any offer, you do your buyer
Yes.
consultation. And there's, first of all, it's on the agency disclosure, it says as soon as possible, you need to have the buyer sign that, the agency disclosure.
Yeah, right,
Yeah.
right.
If the seller has already provided all the disclosures up front, it's easier. We can go over, the buyer can go over all the disclosures and remove, then they can remove the
Correct.
investigation continues. But sometimes
Boy.
the seller does not provide everything, or if they don't provide anything, or if they do, they just do few things like maybe inspections and all that. That's the problem, right?
The buyer may decide not to write an offer because they have something in particular that they are most interested in. Mold is a big one. And if
Yeah.
the buyer is scared of mold, they're going to want a mold inspection. I'm not saying it's a good idea for the seller, but what I'm saying is that they need to be aware that these are possible inspections available, and before they even consider writing any offer.
Mhm. Yep, that buyer inspection election is a pretty important form
Yeah.
when they go over it, because they can check any box they want that they want to do it, and later they can say, no, I'm okay, I don't need to. But reading disclosures from the sellers, oh my gosh, you guys have to read them too. Don't even think your buyer reads them and understands them. You got to read them. If you don't like to read, you're in the wrong business, because this business requires lots and lots of reading.
I know.
Agent visual inspection disclosure. This
Now,
one's so fun.
I'd say one more thing. Quite often now you will see the HOA documents. And
Yeah.
trying to sort through those is a nightmare. There are people out there that will go through those for you and make recommendations. There are some paid services for that, but also one of the lenders will provide that as a service for free.
I've read that, but I have never used it. I just know that when you're writing an offer for like a condominium or townhouse, I think the HOA docs are the most important disclosure you will get.
Buried in one that I sold a couple years ago was a mention that there was going to be an assessment. Didn't say how much, but they said that there's the need for an assessment, and nobody saw it because it's all buried in these documents.
Yep.
And you've got to go through them and read them. Fortunately, the buyer found it.
Oh, good.
Yeah.
Right. I helped some buyers last year buy a condo where there was only like 6% funded. And I said, I said, this is really scary, guys. I said, if they need to do a repair, there's not enough money to do it. And that means you're going to get a special assessment. They were fine. They said, nope, we want to buy it. I actually made them sign something.
That's what
Yes.
happened with Meadowbrook. They didn't have enough money to take
Right.
care of the millions of dollars in repairs.
Right. Now, this condo, they had also done a lot of repairs, which took a lot of the money. And so I said, you do have to look at that. Like if they just did a major paint job or roof job, yeah, their funds are going to be way down. This one was less than 10%. Ooh. Anyway, they still bought it. So
Hey, Pat, I have a
Yeah.
question. Going back to Alameda County disclosures,
Yeah.
are those, do you advise to present those as statewide buyer advisory to the buyers at the first meeting or in advance? So those two go together? If they are in
those two
Alameda?
definitely go together.
Mhm.
When you present it, it's sooner the better. Okay. I actually talk about these things when we're writing an offer, and they will have seen all the disclosures. And I will tell them, make sure that you see in this disclosure specific, whatever it is, this specific disclosure, make sure that you see that somebody died in the property, or that they have, I don't know, noisy neighbors or whatever. Or I'll say, in the seller property questionnaire, make sure you check out number whatever. And I'll say, and then on the Alameda County one, I said, look, you're buying in Oakland, go in there and look at what Oakland has to say. I'll tell them exactly where to look. It's so much harder when I can't sit there in person with them. In person, it's so much easier. I do Zoom with them. And I do a lot of phone conversations. I try to back up my phone conversations with a email.
How long does it take for you to go over all the disclosure before making an offer?
In person, a lot longer than it does today.
Mhm.
It can
Hour.
take, I would say, I usually allow a couple of hours.
Mhm.
I briefly go over every single one and it takes me about an hour.
Right, I try to go over a little bit more than that. So mine's usually, and writing the offer about 2 hours. But yeah, and
Steve will say that's why a buyer's pre-purchase consultation is really important. Steve
Yeah.
does it. He goes over all the forms with the buyer before they ever see a property, even to buy. He
Yeah.
wants them to understand what's involved. But you're buying $1 million property today. That's a tremendous commitment. And you don't take it lightly. Unfortunately, buyers today think it's like going to Amazon.com. You click here and you buy. It's crazy. Especially
Okay.
DocuSign.
I'm going to go on because I do want to end this by 3. And wherever we're at, it's just going to simply end at 3 o'clock. This one here is the agent visual inspection disclosure. Everybody has to do one of these. And it requires the county and the address. This box is checked if it's a duplex, triplex, or fourplex. Then if it should be a fourplex, you will have 4 agent visual inspection disclosures. It's a duplex, you will have 2. Right now, we're not doing that. We're going to say this is a single family resident, okay? And you put in the name of the company that holds your DRE license. For us, it is Keller Williams Benchmark Properties. It is not your team name or your name. It is your company name, the company name who holds your DRE license. And in here, it says what is expected of the agent. This form doesn't expect much, except for visual inspection. Like you're not expected to touch anything really. I do a little bit more than what this inspection says you should do. I do not go into the roof or attic like it says we don't. The interior agent will not move or look under or behind furniture, pictures, wall hangings, floor coverings. Agents will not look up a chimney, right, or into cabinets. I do open cabinet doors, but I don't open to look inside the cabinet. And open lock doors, right? I don't open lock doors. Exterior agent will not inspect beneath the house or other structures of the property. other structure on the property, climb up or down a hillside, move, or look behind plants, bushes, shrubbery, blah, blah, blah. Appliance and systems, agent will not operate appliance and systems, such as, but not limited to, the electrical, plumbing, pool, spa, heater, sprinkler, entertainment, well, water, to determine the functionality. I usually turn on the stovetop, just to see if the burners are working. It is not required, and I possibly shouldn't do that, but I do. Size of property and improvements, agent will not measure square footage. Environmental hazards, agent will not determine if the property has mold or any of those things. Those are for professionals. Off property conditions. By statute, agent is not obligated to pull permits or inspect public records. Agent will not guarantee views or zoning, identify proposed construction or development or changes in proximity to transportation, schools, or law enforcement. Analysis of agent disclosure. For any items disclosed as a result of the agent visual inspection or others, agent will not provide an analysis of or determine the cause of the source, blah, blah. What this means to you, okay, it is, we're just doing a visual inspection. I usually have my buyer with me when I do this, because I like to show them what I'm finding rather than just write it down and try to have them visualize it or remember what the property looked like. So sometimes when I'm showing the property the first time, like we're going in there with our PEAD and I'm really showing it the first time, if they're really interested, I'll do my AVID right then and there, so I don't have to go back in it and they can see what I'm looking at. So you have to, if it is more than one piece of, if it is only a single family home, this can be left blank. If not, you have to state if it's unit number 2, 3, 4, 1, 2, 3, or 4. Inspection performed by Keller Williams Benchmark Properties. Inspection date and time, very important. Time, especially if it's dark, you don't see very well outside. So you are probably going to miss things. Weather conditions, in some areas it could be snowing. Around here it's raining, or maybe it's just a clear day. I always put in the temperature also. I don't know why, I know why I would do that, because if the heater doesn't come on, well, I wouldn't turn it on anyway. I always put in the temperature. Don't know why. Other persons present, I always hope it's my buyer. Sometimes it's the inspector, like the general property inspector. I might do it when he's there. But I prefer to have somebody with me. I don't know why. I just feel more comfortable, especially the buyer. Want the buyer there to see what I'm doing. So in this area, you would just write things that are wrong with the property. I don't need to, we don't want to see beautiful entryway. We want to see entryway cracked tiles, or door doesn't open easily with a key. Door is squeaky when it opens, something like that. We only want negative stuff. I know it's kind of awful, but we only want negative stuff in here. The living room, what you see that is not right with the living room, there might be some cracks above a doorway or above a window. Maybe the windows are filmy. You would say windows are filmy. You would not say broken seal, because you don't know if it's a broken seal. Or you can say broken window. Dining room, kitchen, right? Everything you can see that's wrong about the kitchen. This is where I tend to open cabinet doors and drawers, because sometimes the door will fall off, or the handle is really loose and I wouldn't know it unless I touched it. So, and I'm always wearing plastic gloves these days when I do this.
Yeah, computer पे किया मेरा iPad off हो गया एकदम से sound.
Say it again. Alan, what'd you say?
Oh, sorry. No, nothing. It's okay.
Oh, okay. And then if there's other rooms in the house, then you have the hallway and stairs. Sometimes the stairway railing is loose. You would definitely write that down. The railing is loose. Or if there's any trip hazards on the stairway, like rugs that aren't, like sometimes they have these, carpet or rugs that they've glued down and they're not glued very well. All your bedrooms, your bathrooms. It's best to go along with the person who is coaching you, transaction coaching you, to help you with your first one. A garage, common thing in the garage is stains, cracks in the cement, front and backyard, sometimes uneven pavement or possible trip hazards. I never say anything is for sure. It's possible, could be, that kind of stuff. And then in here, the brokerage firm who is doing the inspection. So if you're doing it, it's Keller Williams Benchmark Properties, and your signature and the date you're doing it. Then down here, buyer and seller sign. And then again, once again, you have to do it. So whoever you're representing, buyer or seller, you would put your information in again. Questions?
Yes, I do have a question, couple, if I may.
Yeah.
So do you ask if I don't do the avid with the buyers at the first showing, do you ask the listing agent or / seller to allow you for avid? And when do you do it? After
Well,
offering?
if I don't do it when I'm showing it initially, then I don't do it until we've written an offer and gotten it accepted.
And then the next day you go, or how soon after that?
Well, I set it up because I want my buyer there. I really want my buyer there. So I try to set it up with them, ask them what time they can be there with me. And as soon as possible, because you need this disclosure in really quickly. And if you've already removed all your disclosures, the buyer can't even back out for this. And hopefully the seller will still let you in. And I would say most sellers will still let you in to do this, most sellers agents.
So can you tell them, thank you for accepting my offer. The next thing is coming in for avid. Can I bring the buyers with me?
Well, you can. Yeah, you can. You would just have them sign a PEAD.
Okay.
Great. If you can get in, you can bring your buyer with you.
Okay, even if it's
Now,
not
where you're going to run into trouble is if there's a tenant. See, so if there's a tenant in the property,
so
whether
even if
you
it's
think your buyer is going to buy it or
non-contingent,
not,
I
I
can
would
bring
do
the
I would do the AVID, just because you might not get back in. So look to see if there's tenants in the property, automatically do your
Okay.
AVID regardless. It's a simple thing to
And
do.
if there's
What?
yeah, just the little things to figure that out. If there's nothing to note, can we write nothing to note?
You mean nothing to note that's wrong with the whole house?
There would be something.
No, no. There is something wrong with each and
No,
every
no,
house.
like bedroom 1 or bedroom 2.
Just leave it blank.
Pat,
Or
they
you
need
can
to
just-
fill out each line. With either I saw nothing to report,
For
or
NA,
it's not applicable, but you need to fill in every line.
I do not. I fill in
should.
only the lines that have something, but what you're saying, Jerry, makes a lot of sense.
Yeah.
That way they know that you saw it.
Yes, yeah.
But we will never accept a nothing wrong with the house.
Yeah. Yeah.
Pat,
I mean, we just got one of those. I'm not kidding. We just got one from an agent. Anyway. It's frustrating.
So say you go to 3 homes to view them, do you fill one out for each home?
Well, when I go in, if the buyer says, I think we're going to write an offer, yes, I do it. If the buyer says, no, I don't think we're going to write an offer on this one, then I don't. Should they turn around and write an offer on it, I go back in and do it later. Sometimes I'll go back in just before the offers are due, see if I can't find an open spot and go back in and do it myself, just so I can get it done and send it to the agent with my offer. I like to send it to the agent with my offer.
Oh,
That's my whole thing, is the agent knows I've already done it and the buyer has seen what's wrong with the house visually. That is my goal, is to send the AVID with my purchase agreement. And then I mark it in a box on page 3, I think. One of those other boxes, and say AVID.
You might mention the 3-day cancellation if the listing agent has not done this yet.
Yeah, I'm just doing disclosures. Not
Yeah,
doing
that is
cancellations.
disclosure. The listing agent needs to fill out their AVID.
Yes.
And if they haven't done it, the buyer has the right up until they actually do it to cancel the contract for any reason.
Well, there's other things in here too, like we'll go, oh man, I got only 8 minutes. So this one here, this is really interesting. If the So here's where I was talking about the civil code thing that talks about the agency relationship. That's what this is all about, is that agency relationship. I think if I'm remembering properly, I think it's the agency thing. But here, if the listing agent hasn't marked any of those boxes, they have not given you a completed TDS. And the contract says they must give you a completed TDS. The buyer can back out at any time.
Can you zoom in?
Oh, yes, sorry, thank you.
Thank you.
Okay. So these 3 boxes right here, that one of these boxes has to be checked. So if you say no substituted disclosures for this transfer, that means there's not even a natural hazard disclosure report. If there is, then then this box and probably this box would be checked, 1 and 2. But it's inspection reports completed pursuant to contract of sale or receipt for deposit. So contract of sale is the day it's accepted, a receipt for deposit, which may be 3 days after it's accepted. If any reports are completed pursuant to those, that box would be checked. So anything that's on the MLS already done would be checked. Additional inspection reports and disclosures might put in preliminary title, natural hazard disclosure. I put them general property, pest. I put, all personal disclosures. I put everything in there, but I use very vaguely. I don't list each personal disclosure. I just say personal disclosures, advisories, yeah, things like that. But if those aren't checked, your seller has not completed his TDS. And you do have the right to back out. I think it would be hard, and I think it would be a fight on the seller's side, but pretty sure they would probably lose that one. Seller discloses following information. This is very important, that you yourself as a buyer's agent see if the buyer is living in the property or not. If they are not occupying the property, they're going to know less about the property than somebody who is occupying it. Doesn't mean they're exempt from filling out things, because just because they don't live there, they still need to know some things about the property. They just won't know everything. So whatever applies, the property has. Now, if any of these things aren't working, they're in the house, because if they're there, you have to mark it. And if they're not working, then you say so down here. Are there, to the best of your seller's knowledge, any of the above that are not in operating condition? It's a yes or no question. It's not, I don't know. It's a yes or no. In here, there are exhaust fans. This is where sometimes I help my sellers a little. They'll say any exhaust, like they'll leave it blank, and I'll say, you don't have any exhaust fans? I'm like, you have one above your stove? You have one in the bathrooms? You have one in the laundry room? Let's, oh yeah, we got exhaust fans. And 220-volt wiring. I always go about do you have an electric dryer? Do you have an electric stove? Fireplace? They don't even know how to answer any of this stuff. And so I feel like if they don't know how to answer it, they need some help, just some guidance. Like, I can't answer it for them, but I can guide them through it. Questions on this page?
This is another form I sit down and walk through it with.
Oh, so do I.
You have to. They don't know how to fill this out.
Right. Yeah, and if I do it, even if I'm doing it on Zoom now, I'll go over this. This is one, right, where I sit in front of them, Zoom or in person, and I go over this form with them, because it is a tough form. Then we have, are you the seller aware of any significant defects, malfunctions, or any of the following? Again, it's a yes or a no question. It's not a blank, and one of them has to be checked. And then there are these items that they say, are they in malfunctioning? Are they working condition? That kind of thing. Then you would explain it if they are not in working condition. Then we get down to a bunch of other important questions. This is like the most important disclosure there is, guys. Are you, the seller, aware of any of the following items? There is no I don't know. Because they're going to say something, you're going to say, they're going to come to a question, they'll say, I don't know. And are you aware of? Then it would be no, they're not aware of it. So that's how you guide them. Those I don't knows don't work. Substance material. So they would just go through every one of these questions. Neighborhood noise problems and other nuisances. They usually say no. And then it's, I have to like trigger their memory. Like they've forgotten about that train, or they've forgotten about all those kids that play outside in the summertime, or there's a school nearby that makes a lot of noise when it's in session. So sometimes you just have to trigger their memory. And if they still say no, then you go along with their answer, because they are doing it to the best of their knowledge, what they are aware of. I don't have enough time to go over all these questions. Seller certifies that the property as of close of escrow will be in compliance. This is the smoke detectors, and this one is the strapping of the water heater. So that's why we don't need a smoke detector water heater disclosure anymore, unless you don't do this form, because there are times when this form is not done. Seller signs. Agent marks one of these boxes. You, as an agent, will mark, see attached AVID, or agent notes the following items. AVID to follow. Okay, that's the only thing I'll allow you to write in there. So you can either check this one, or you will say AVID to follow, because you just can't get out of doing one. And then you see all these signatures that have to take place down here. So you'll be signing a couple of times. Seller and buyer sign a couple of times. I guess buyer once, seller twice. Questions on this one? Wow, I must have done a good job. I went over it so fast that I'm going to stop here. I'm not going to go on because it's 3 o'clock. Jerry, are you still there?
Yeah, I am. And
So I'm
probably,
going to show you after all this how to get the name of the person in there
yeah,
without the trustee.
that would be nice. Thank you.
Okay, so I'm done, guys. Thank you for attending. I don't even know how many of you were here, because I'm not using my own Zoom, and it's not, oh, there were 17 right
17
now.
are on.
Yes. How many were total? Did anybody drop out?
I think one dropped out and one came on afterwards.
Yeah, Pushpa left, I think.
Oh, did she? Yeah, I didn't think she could stay the whole time.
Rosie is here.
Rosie.
Hi, Rosie.
I'm here.
Hey,
Hi there.
Rosie. Oh my gosh.
Hi there.
Wow, I haven't seen you in a long time.
That was really good. Lot of information.
Oh, thank you, Alan.
We still have a few other disclosures, right? So you have to.
Yeah, but I don't, it's 3 o'clock. I've got some
I
other
know.
things to do. Yes.
I know.
But I do want to go and show this. Okay, so let's say you've got your documents and you've got your trust. You go to parties. See that word? Are you guys seeing this? Are you seeing this?
Yeah. Yeah.
Okay, so you go to parties and you would fill in buyer one with, let's say it is trust. Let's see, is it not going to let me do anything? Okay, it's not going to let me do anything. You would fill in John Doe Trust.
Underneath,
What do you mean underneath?
the second line.
Here? Oh, sorry. Yes. Oh, I'm sorry. Thank you.
Sure.
John Doe revocable. I might spell things wrong here. Revocable trust. Actually, we're going to do Doe revocable trust.
I'm sorry.
I know. Let's take some of this stuff off. I don't know what would happen if I put it all under the first name. And then you would put in the email.
It probably
So we're
would.
gonna,
Thank you for this class, Pat. It was very informative.
thank you for attending. Okay, then you would go down here, and this is how they will sign. John Doe And if you want to put trustee behind it, you can, but you don't have to because of that other form. And you will then put in the email. We're not going to do that email anymore. We're going to do just this email. There. And now it will come up. He will be signing John Doe, but this will be showing in all the forms.
So if you put John Doe after Doe, you go comma trustee. That would fill it in then each time, huh?
Yeah, you could just do comma down here,
Yeah.
trustee, right? And it will now be, but then the initials are going to come up JDT.
Oh, is that what
Okay.
happened?
Yeah, so that's why you will probably not want to do that. And you can put or you can just do John Doe trustee up here and not do the revocable trust unless there's a trust that is buying it. So, it might be a trust buying a property, and then you would want all of this up here because it's a trust buying it, not John Doe. But John Doe is going to sign. And then you can also do save and have a second buyer.
Okay.
Yeah. So this is how you get that in. It's that parties.
We'll play with that. Thank you.
Yeah. It was such a wonderful, fantastic finding. Oh my gosh.
I know, and I'm gonna need it today.
Yes, okay. So remember that parties.
So the first
Wait,
part
that's-
is the trustee, last name, trustee, and the second signing representative is just the name. For
Yes, just the
individuals.
name. Just the name. And up above it has all the trust stuff or the LLC or the conservatorship or whatever. But down below, just the names that are going to be signing. And if there's two of them, then you do up two. So you'd have buyer 1, buyer 2, buyer 3, whatever.